Dear Professor Watson, welcome on NaspRead. So your research focuses on epistemic rights. So what do you mean by epistemic rights, and who could claim such kind of rights?
So epistemic rights are a fully fledged form of rights in my view, and they're rights that concern epistemic goods. So rights to knowledge, rights to information, rights to understanding, rights to truth. And more formally, I characterize an epistemic right as a complex entitlement that provides justification for the performance and prohibition of actions and omissions concerning epistemic goods. That's the kind of formal account of epistemic rights, but essentially they're rights to things like knowledge and information. We can all have them, anyone who is a right holder, and that's obviously a complex territory in its own right. But if you are a right holder, then you are eligible, and you probably do have epistemic rights. And then there are different ways to work out which particular epistemic rights any one person might have.
For any right to exist, there must be a correspondent duty. So are epistemic rights granted in any way?
Yeah, so that's exactly right. In terms of epistemic rights, the category that I think is most important and interesting is the category of claim rights. And those rights correlate with epistemic duties on the behalf of duty bearers in response to the claim of the right holder. I think that we work out who has particular duties and who has particular rights by working out when epistemic duties are either morally or legally enforceable. And again, that's like complex territory, but the general heuristic for determining who has epistemic rights relies on determining who has corresponding epistemic duties. So, for example, if I go to my doctor and I have a medical test, I have a right to know the results of the medical test, and that's an epistemic right, a right to know, and that correlates with the duty, an epistemic duty on behalf of my doctor to give me the accurate test results.
Why do we need epistemic rights? I mean, aren't they included already granted under other existing kind of rights?
No, I think this is an important question, and one of the main reasons why I've written a book about this and I'm pursuing this topic is because I do think there's a role, an independent role, for the notion of epistemic rights and rights to know that isn't like fully recognized in our kind of moral language, but also maybe perhaps more importantly within our legal frameworks. So there are cases where, for example, in the doctor case, right, some of my rights are covered by patient rights. I have rights as a patient, and that's a subcategory of rights, which are legal rights and moral rights. But epistemic rights are also, I think, a unified subcategory of rights, both legal and moral rights, not in their own category, but a category of legal and moral rights that we need to draw attention to in order to make sense of a wide range of harms and wrongs that do take place within the epistemic domain in particular. So I can hold a person, a duty bearer, to account not just for kind of some sort of ethical misdemeanor, but for an ethical misdemeanor that has an epistemic component. So holding politicians to account for lying, for example, is like a thorny territory, but it might be a territory that we could explore if we can deploy the concept of epistemic rights, rights to the truth from politicians, for example, rather than relying on other kinds of rights that don't take into account the role of truth and information as explicitly.
Which do you think could be the first step to realize in concrete your proposal?
We do have various laws scattered about the place that are explicitly targeting our epistemic rights. I mean, the case of kind of libel and slander, these are cases which in the media domain concern falsehoods that are reported in the media, but they very rarely extend to, or they basically don't extend to, the general population. You have to be, someone whose reputation has been damaged as a politician or as a celebrity or something in order to bring that type of case. And I think there's room to expand that to other types of falsehoods being propagated by the media. For example, that's just one example. Same goes for, big pharmaceutical company, the big pharma case that I have at the heart of the book. is all about the pharmaceutical company Purdue Pharma, who was taken to court and charged for essentially defrauding the American public by making false claims about the addictiveness of the opioid-based painkiller OxyContin. And there we have like a really, really clear case in which we can use legal frameworks to protect epistemic rights. And the first step is basically just working out those mechanisms and then extending them to all the cases that we think really matter.